Clayton Act, Chapter 323 of the 63rd Congress of 38, Statute 730, has amended Public Law 108-237 enacted June 22, 2004. An act to supplement existing laws against restraints and monopolies and for other purposes, but be it enacted with the Senate, House of Representatives of the United States of America, assembled with the antitrust law with the hereby included with the act and the title of the act, protect with the trade with the commerce against the unlawful restraint of the monopolies. Approved July 2nd, 890, Section 73 of the 76th, inclusive of the act and the title of the act with the reduced taxation to provide revenue for the government. For other purposes, like August 27th of the 1894, enacted with the date, Act with Amendment 7, Section 73 of the 76 of the Act, August 27th of the 1894, Act with an Act of reduced taxation to provide revenue for the government for other purposes than approved the February 12th of 1913. Also for this Act, Commerce also here with the, let's go over to the Act, Commerce, as used herein, may be the trade with the commerce of the civil, the trade with the foreign nation, with the between, with the District of Columbia, the territory, the United States, with any state, with the territory, force, nation, between, insular possession, with the other play, with the jurisdiction of the United States, between, any possession, play, with the trade, with the territory, with the United States, with the District and foreign nation, with the District of Columbia, and territory, with the insular, with the possession of the public, other place under jurisdiction of the United States, with the provided here, nothing in the act contained shall but apply with the Philippine Islands. Will a person, whenever you, the act shall the team with incorporate, corporation, association, existing law, authorized by the laws of either the United States, the law of any of the territory, laws of any of the laws of the either country. 1. As amended through Public Law 108-237 enacted 22nd of 2004. The Clayton Act. B. This act may be cited as the Clayton Act. Section 2 of this shall be unlawful to any person who engaged with the commerce and course of such commerce, but either directly or indirectly discriminate of the price between the different purchase of the commodity or like of the great quality with either with any of the purchases involved with some of the discrimination commerce where such commodities are sold for use of consumption resale within the United States, with the territory throughout the District of Columbia, ancillary or possession, other place under jurisdiction of the United States where the effect of the discrimination may substantially lessen the competition intended to create a monopoly, any line with the commerce, injure, destroy, or prevent competition with any of the person with who there either grants knowingly receive benefits for the discrimination with the customers, with either with the provided with nothing due and nothing here contained should be providential, prevent differential of the making only due allowance for the difference of the cost manufacturing, save the delivery resulting from the difference of the quantities in which the commodities are such for the purchasers sold delivered provided. However, the Federal Trade Commission may, after due investigation hearing to all interested parties, fix and establish quantity limited to revise the same if the find necessary particular commodity of the classes of the commodities where it be found available to purchase and greater qualities, so fewer rendered differentials account, therefore unjustly discriminate or promote of the monopoly in any line of the commerce. Foregoing shall not be construed to permit the differentials based on the difference of quantities greater than those of the so fixed and established, and provide further that nothing here contained with the prevent person engaged in selling goods, wares, or merchandise in commerce selecting their customers in bona fide transaction, not in restraint of trade, and provided with the further that nothing here contained shall prevent with the price change for the time wherein response change conditions affected the market with the marketable with a good concern shall not be limited to the actual and imminent deterioration of the perishable goods, obsolescence, or seasonal goods, distress sales under the court process sales in good faith of the discontinuance of business and either upon good concern. Be upon proof being made of any of the hearing complaint under section that there the discrimination and private services facilities furnishing burden with the rebuting of the preliminary case of the phase thus made with the show of the justification shall be upon the person charged with the violation section unless justification affirmatively show that the commission is authorized to issue an order terminating discrimination, provided however that nothing here contained all prevent seller rebutting premium facie of the cases that does made by showing them the lower prices or the furnishing service facilities to the any of the purchaser was made with a good faith of the meet with the equal low price for the competitor or service the facilitators furnished by a competitor, that this is unlawful to any person engaging in the commerce within the course of such commerce to pay or grant to or to receive and accept anything of value for the commission, brokerage for the other compensation, along with the discontinuance, the lieu of the accept of the service rendered for the connection and sale of the purchase of the good ware of the merchandise, either for the parties such for the transaction agent representing the other intermediary therein, with the intermediary acting factor on behalf of the subject direct and indirect control any of the parties of the transaction other than the person whom such for the compensation is granted or paid. D, that it shall be unlawful to any person to engage with the commerce and pay or contract for the payment anything of the value or benefit of a customer, such as a person in such a course of the commerce of compensation consideration for any service of facilities furnished by through such customer in connection with the process handling, sale of the offering, sale of any of the product commodities, both manufactured, sold, the offered, sale of the by the person unless the payment of consideration available to proportional equal terms for all the customers competing into the distribution of such product commodities. Alright, there should be unlawful the person discriminate in the favor of the one person purchaser against the other purchaser or the purchaser of the commodity brought to the resale with or without processing by the contracting to furnish or furnishing by the contribution of the furnishing any service facility connected with the process of the handling, sale, of the offering and sale of the commodity purchased for the upon with the terms of not accorded to all purchase of the proportional equal terms that it shall be unlawful to any person engaged with the commerce for the course of the commerce not only to do for the receive the discrimination in price which is prohibited by this section. Section 3, there shall be unlawful to any of the person engaged with the commerce of such course of the commerce for the lease for the market, sale of the contract with the sale of the good ways, whereas merchandise, machinery, supply of the other commodities, wherever the patent, unpatented for the use for the consumption, resale of the United States, of the territory through the District Columbia, or any ancillary possession taken into the jurisdiction of the United States, or fix a price charge thereof with a discount with a rebate upon such price with the condition agreement and understanding that the lesser purchaser thereof shall not be able to deal with the goods and wares for the merchandise of the machinery supply with the other commodity for the competitor of the competitors of the lesser leaser or seller, whether effective such to leave for the sale of the contract, sale of the Dutch condition agreement and understand may not be substantially less in competition to 10 creative monopoly in any line of the commerce. Section 4, except as provided in subsection B, any person who shall be injured in business property by reason of any of the forbidding antitrust law may sue therefore in district court of the United States for the district in which the defendant resides and found or has an agent without respect to the amount of the controversy shall recover threefold of the damages by him sustained by the cause of suit, including was reasonable attorney's fee of the court may be to award with the section pursuant to the motion, such as the person promptly made with the simply interest for the actual damage period beginning with the date of service of the person pleading set forth for the claim under the antitrust law of the ending of the date of judgment for any short period therein, when the court finds that the award of such interest for the just period with the just of the circumstance of determining whether the award of the interest of this section for any period is just in circumstances that short court should consider. Whether such person of the opposing party, either with the party represented, made motion assertive claims of the defense for the lacking of the merit with show of the other party, the representative, the action initially delayed with the otherwise acted in bad faith, whether the court's action involved the choice of the person opposing party, either party's representative violation of applicable rule, state, statute, court order, providing with the sanction of dilatory behavior, otherwise providing expeditious proceedings, through which, whether such a person opposing a party, either party's representative engaged in conduct prominently for the purpose of delaying litigation, increase for the cost thereof, be one except the providing paragraph 2, any person who, with the foreign state may not cover the under subsection A, the amount of the excess of the actual damage sustained with the cost of suit, would include a reasonable attorney fee. Through paragraph shall not apply with the foreign state, but the foreign A, such foreign state shall be denied under section 1605A2 with the Title 28 United States Code, the immunity with the case of the action based upon the commercial activity or in the act of the subject matter claimed under section B, such foreign state waived all defenses based upon the rising of the status of the foreign state to any claim of the brought of against the same action. C, this foreign state is primarily in commercial activity. D, such foreign state does not function with respect to the commercial activity of the act that is subject matter of the claim and under the section of the procurement entity of the other foreign sale for the purpose of this section. The term commercial activity shall have the meaning given in section 1603 with the Title 28 United States Code, and the term foreign state shall have the meaning given in section 1603A with the Title 28 United States Code. Alright, section 4A, whenever the United States here with an injured for the business, whenever the United States is hereafter injured in his business property reason any other forbidding antitrust law with the may sue, therefore The United States District Court for the district where the defendant resides or is found over the agent with respect to the amount of the controversy shall recover their damage if it is sustained with the cost of suit with the court awarded with the section pursuant with the motion of the United States with the promote may properly made with a simple interest for the actual with the damage of the period beginning with the day of the service of pleading with the United States setting with a claim with the under antitrust law with the ending with the day of judgment for any short period with the hearing that court find with the award with the such with the interest of the period in just circumstance with determining whether an award interest done with the section for any period is just for the circumstance with the court should consider only with the United States with the opposing part of the either of the party represented made motion asserted claims the defense of lacking in merit with the show of the such party of the representative the act initially for delay otherwise acting in bad faith. 2. Whether the course of the action involved with the United States with the opposing party, either party of the representative violated applicable rules, state statutes, court order providing sanction for the dilatory behavior of the others, provided with the expeditious proceeding, whether the United States with the opposing party of either party's representative engaged with the conduct primarily for the purpose of delaying litigation, increasing the cost thereof, whether the award such interest necessary with the compensation of the United States adequately for the injury sustained by the United States. Alright, Section 4B, any action enforce any cause for the action under Section 4A, 4A, or 4C shall be forever barred unless commenced within 4 years after the cause of the action accrued with no cause of the action barred against existing law effective date shall be revived by this action. Actions by State Attorney General, Section 4CA1, an Attorney General of the state bringing with a civil action in the name of the state, such state with the parents of the portray, on behalf of the natural person residing in such a state with the District Court of the United States with the having jurisdiction defendant to give the monetary relief of the providing section of the injured sustained by each such natural person with the property by reason of any violation of the Sherman Act, the court shall exclude the amount of the monetary relief of the award of such action and amount of the monetary relief which duplicates up amounts of that have been awarded for the same injury, which is properly allocable for the natural person who have excluded with the claims pursuant to subsection B2 with the section 2, any business entity. The court shall be awarded with the same monetary relief at the threefold with the total damage sustained described in paragraph 1 of the subsection of the cost with including the reasonable attorney fee, but the court may be awarded with the paragraph pursuant with the motion of the state with the promptly made with the simple interest of the total damage of the period beginning with the day of service of such state pleading set forth for the claim under antitrust law with ending with the day of the judgment and further any shorter period therein the court finds with the award with the interest such period with the just circumstance and determining whether the award interest in the paragraph or any period within the just circumstance of the court shall be considered a where the state with the opposing party either the party represented made motions asserted claims of the defense over the lacking in the merit with the show that such a party of the representative acting intentionally for delay or otherwise acting in bad faith, whether the course of the action involved such of the state opposing party that either party representing violated the applicable rules, station court order provided the station sanctions of the dilatory behavior otherwise provided with the expedition proceeding, whether such of the state of the opposing party with the party representative gave the conduct primarily for the purpose of delaying litigation, increasing the cost thereof, the B1 and action brought with the subsection A1 of the section State Attorney General at such time as the manner such a content with the court may direct cause of the notice thereof, the given by publication the court finds the notice given solely with the publication generally deny and due process of the law that any of the person of the court direct further notice to such of the person according to the circumstances in the case. 2. Any person who, with the behalf of the action brought in the subsection A1 may exclude the exjunction of the portion of the state of the claim of the monetary relief of the tribute to him with the filing with the notice for the stuff of the election with the court when to such time certified notice given the pursuant of the paragraph 1 of the subsection final judgment action of the under section A1 shall be the res judica as the claim under section 4 of the act of the person behalf of the such for the action brought with the who gives fails to give the notice of the period specified by the notice given and pursuant with the paragraph 1 of the subsection action of the under subsection A which shall be dismissed with the compromise without approval of the court. Notice of the proposed dismissal of the compromise shall be given in such a manner that the court directs any direction of subsection A the amount of the plaintiff's attorney fee if any of it shall be determined by the court discretion award with the reasonable attorney fee for the prevailing defendant with the finding state attorney general has acted in bad faith vexatiously and wantonly for the oppressive reasons. Alright, measurement of the damages, Section 4D, with any of the under Section 4CA, with the determination of the defendant agree with the fixed price violation, Sherman Act, with the damage provided with the set for the aggregate, with the statistical, with the sampling method by computation and legal overcharge by such with a reasonable system of the system aggregating with the damage of the court with the discretion, maybe the permit with the necessity separately, providing the individual claim of the amount of the damage person who is on the behalf of the suit was proposed. What suit was brought. Distribution of the damages, Section 4.2 of the monetary relief record of the covered in an accident under Section 4CA shall be distributed in such a manner that the district court with the discretion may authorize the deemed the civil penalty of the court deposit with the state of the general revenue subject in either case of the requirement that any distribution procedure is after afforded for each of the person reasonable opportunity to secure his appropriate portion of the net monetary relief. Actions of the Attorney General of the United States, Section 4FA. Whenever the Attorney General of the United States has brought action under the antitrust law, with the have the reason to believe that the state of the Attorney General will be entitled to bring an action under the act based substantially the same in the alleged violation of antitrust laws, shall promptly give the written notification thereof of the state of the Attorney General. To assist the state Attorney General with evaluating of the bringing any action for the act of the Attorney General of the United States shall, upon the request of the state Attorney, make available to him, with the extent of the permitted by law, any of the investigation files, other materials which are maybe relevant to the material, the actual potential cause of the action under act. Section 4G, for the purpose of the Section 4C, 4D, 4E, and 4F of this Act, from State Attorney General, the means of the Chief Legal Officer of the State, any other person authorized by the legal law, bring action under Section 4C with this Act, include with the Corporation Council of the District of Columbia, except for the sum of the terms does not include with any person employed with a retain on a contingency fee based on the percentage of the monetary relief awarded under this section, or any contingency fee based on the levies for the amount of the award, reasonable attorney for the prevailing plaintiff is determined of the court under the Section 4CD1. The term of state means of the state of the District of Columbia, the Commonwealth of Puerto Rico, any of the territory possession of the United States, with the term of the natural person that does not include the proprietorship of the partnership. Applicability parents of the parche action of Section 4H, Section 4C, 4D, 4E, 4G shall apply with the state unless for the state provided by law with non-applicability of such state. Section 5, a final judgment of the decree thereof the hero of the render of any civil criminal procedure brought on behalf of the United States with the antitrust law with effect with the defendant with the violated said law shall be prima facie for the evidence given the defendant with the inaction perceived with the brought any of the other part of the against the defendant with the undersaw law with the other material the representative of the said judgment the decree of the would be estoppable as of the between the part of the desire to the provide this section shall be not applied with the consent with the judgment the decree of the enter of the before with any testimony has been taken not contained within the section shall be contributed and the limitation of the application of the collateral estoppel except within the action of the proceeding brought on of the antitrust collateral estoppel after shall not be given into any of the finding of the made with the Federal Trade Commission under the antitrust laws under Section 5 of the Federal Trade Commission Act, which could give the rise of the claim to relief under the antitrust laws. Any proposal of the consent of the judgment submitted with the United States with the entry of the civil to proceed with the behalf of the United States under the antitrust law shall be filed with the district court before the such for the proceeding pending with the published in the United States with the Federal Register at least 60 days prior to the effective date of such judgment. Any written comments relating with the of the proposal or respond with the United States with thereto with the also be filed with the of the district with the court and published with the United States with the Federal Register, served with the 60-day with the period of copies of the proposal to any other the material document in the United States with the consider the determined formulating the proposal shall also be made available to the public of the district court. Such other district courts may be substantial to directly unintensive filing except for the proposal unless otherwise instructed the United States shall file with the district court published in the Federal Register thereafter furnish any of the person upon with the request competitive impact of the statement that shall recite nature of the purpose of the description and practice of the events of the rising given the alleged violation of antitrust laws, examination proposal, the consent of the judgment, including the explanation of the unusual circumstances given in the right of the proposal, the provision contained with the relief of the be obtained, and anticipated effect of the competition, such relief of the remedies available to potential private plaintiffs, damage or alleged violation event with the proposal, the consent judgment, and inventor in such proceeding, the descriptive procedure available, the modifications of each of the proposal, descriptive evaluation, alternatives of the proposal, actually considered the United States. The United States shall also cover the published for the commencing with at least 60 days prior to the effective date of the judgment described in subsection B, and then section 7 days over the period or 2 weeks newspaper the general circulation from the district with which the case of the file with the District of Columbia and such other district of the court may be directed. 1. A summary of the terms of the proposal, the concept of the judgment, the summary of the competitive impact statement, the file with under subsection B. 3. A list of the material, the documents under subsection of the United States shall make it available for the purpose of the meaningful of the public comment and the place where the such material of the documents are available for public inspection. During 60-day period with the specified with the subsection B with the at additional time the United States may request for the court may grant that the United States shall receive the consent of the written comments relating to the proposal, the consent of the judgment submitted with the subsection B by the Attorney General and his designee shall establish the procedure to carry out with the provision of subsection, but the 60-day time period shall not be shortened except by order of the district court showing that one extraordinary circumstances require the such shortening, and two, with the such shortening not adverse with the public interest of the close of the proper period during the the comments are received the opponent of the United States shall file with the district court with the cause of the publisher with the Federal Register or response to such comments upon with the applicant of the United States. District court may or good based on the finding of the expense of the publication of the Federal Register receive with the public interest of the benefits to gain with the first such publication authorized with the alternative method of public dissemination. Public comments to receive the response of those comments before entering any consent and judgment proposed of the United States within the section of the court shall determine that for the entry of the judgment public interest for the purpose of such determination for the court shall consider the competitive impact of the judgment, including the determination of alleged violation provisions for enforcement, modification, duration, relief, solve the anticipated effect of the alternative remedies actually considered whether it was determined that ambiguous any other competitive consideration bearing the adequacy such judgment in the court deemed it necessary to determine whether the consent of the judgment is public interest the impact of the entry of such judgment on the completion of the relevant markets upon the public generally with the individual alleging specifically injury with the violation set forth for the compliant, including the consideration of public benefit, if any, to be derived with the determination issued with the trial with nothing in sections but contribute the required of the court with the evidentiary hearing or to require of the court to permit anyone to intervene. It may make the determination on such section E, but the court may take the testimony of governmental officials, expert with the stuff of the expert witnesses upon motion of any of the party and participants upon its own motion, as the court may deem it appropriate to appoint special men such outside consultant with the expert witness for the court may deem it appropriate to require for the obtainment of views, the evaluation, the advice of the individual group of the agency of the government with respect to after the proposed judgment effect with such judgment in such a manner with the court deemed appropriate to authorize the limited participation proceeding before the court interested persons or agencies, including appearances of misca crua interventive of the party pursuant to the federal rules, civil procedure, the examination of the witness, documentary material of the participation, any other manner with extent of the serve of the public interest of the court that may deem it appropriate. Review of the comments include the objection filed with the United States with the under subsection D with the concern of the proposed judgment of the response of the United States with the comments for the objection of the other action of the public interest of the court may deem appropriate not later than 10 days following the day of the filing of the proposal of consent with the judgment under subsection B with the defendant with the shall file with the district court with the restriction of any of all the written original oral communications on or behalf of the defendant, including any of all written oral communication on the behalf of the defendant by an officer, director of the employee with their agent of the defendant or other person with the officer or employee of the United States concerning the relevant to such proposal, except as any of the such communication made with the counsel of the record alone with the Attorney General or the employee with the Department of Justice shall be excluded with the requirements of the subsection private to entry the consent with the judgment pursuant to the antitrust law of the each of the defendant shall certify district court with the requirements of the subsection have been complied with and such filing with the true completion of the description of the communication known with the defendant, which of the defendant reason should have known. Proceeding before the district of the court in subsection E and F of the competitive impact statement to file with the subsection B with the section shall not be admissible against the defendant. Any action proceeding brought with it by any other against the sub of the defeating under antitrust laws by the United States under section 4A over this act not considered the basis of the introduction of the consent judgment prima facie of the evidence given to the side of the defendant any such action proceeding. Whenever there is any civil or criminal proceeding with the Institute of the United States to prevent restraint of the punishment violation of any of the antitrust laws, not including any action under section A4A, running statute of limitation in respect of every private of the state with the right of action under said law of the base and whole with the in part with the matter complained with the said with the proceedings shall be suspended during pendency with the air of the 1 year after provided help with whenever the running of the statute of the limitation in respect with the cause of the action arise under section 4 and 4C. It's suspending here under any of the action for such of the cause of the acts shall be forever barred unless the commence either within a period of suspension within 4 years after the cause of the action accrued. Section 6 of the labor of the human being is not commodity with the article of the common does not contain with the antitrust law of the construct of the floor, but it exists in the operation of the labor, the agricultural home or agricultural organization institute with the purpose of the mutual help, not having capital staff with the conducted from the for-profit, the forbidding restraint with the individual membership of the organization lawfully for legal legitimate object, therefore, no such organization with the members thereof to be held with the country with the illegal combination, conspiracy, and restraint over the trade of the other antitrust laws. Section 7. No person engaged with the commerce from the act of the effect of the commerce shall acquire with the directly, indirectly, with the whole, any with the part, with the shop, with the other share of the capital. No person with the subject of the jurisdiction of the Federal Trade Commission shall acquire with the whole, any with the part, with the asset, with another person engaged also in commerce from the act of the effect of the commerce, wherein with any line with the commerce and effect with the affecting commerce in any with the section of the country and effect with the acquisition may be substantially less than the competition with the 10th degree with a monopoly. No person shall acquire directly, indirectly, by the whole, any with the part of the tax, other share of capital with the person subject to the jurisdiction Federal Trade Commission shall acquire whole or any part asset of one or more person engaged in the commerce for the activity effective of the commerce, and while any line with the commerce for the affecting or effective commerce in any section of the country effective the acquisition of the stocks of the asset of the tax voting granting and property otherwise substantially less than the competition with the 10th degree of the monopoly. This section does not apply with the purchasing except for the tax of the investment not even the same with the voting otherwise bring it out with the attempt to bring out with a substantial lessening of the competition, nor shall any of the contained within this section preventing the corporation gave the commerce for the activation of the effect of the commerce cause of the formation of subsidiary corporations the actual carrying on their immediate lawful division of the natural legitimate branch of the extent of their other than from owing and holding all part of the stock of the subsidiary corporations when the effect of the formation not substantial less than the competition. There are such anything with the aim of the contribute with the prohibited any with the common carry subject to the legal laws regulate the commons from the aiding with the construction of the branch of short lines is located with the make become feeder with the main line with the company aiding such for the construction acquiring owning all any with the part of the stock such of the branch is to prevent any such common carry with the acquiring owning all any with the part such of the stock of the branch short line constructed with an independent company where there is no substantial competition between the company owing the branch line with the construction of the company with the owning the main line with acquiring the property interest in their aim in order to prevent such common carry extending any of its lines through the medium of the acquisition cycle otherwise any other common carry with where there is no substantial competition between the company extending its line and companies whose stock and property or interest therein is acquired. Nothing contained in the section should be held with the fact that any of the right thereof of the legally required, provided that nothing in the section should be held with the contribute the authorized made for the lawful, anything there prohibited by any illegal to be anti-traffic law, nor accept that any for the person penable provision thereof civil remedies for the herein provided. Nothing contained in the section shall apply with the transactions consummated with pursuit and for any of the given the Secretary of the Transportation Federal Power Commissions or for the Transportation Board Security Exchange Commission in exercise jurisdiction Section 10 Public Utility Holding Company Act 1935 United States Maritime Commission or Secretary of Agriculture under the statutory provision vesting in such powers the Commission boards or and Secretary. Section 7A, except for the pursuant of subsection C, that no person shall acquire the directly, indirectly voting security of any of the other person of the person within case of the attending other acquiring person of the file notification pursuant to the rules subsection D1 waiting period is described in subsection B1 if it expired, if the acquiring person of the person voting in the security asset that has been acquired engaged in the commerce within any activity affecting commerce as a result of the such of the acquisition acquiring person from the aggregate the total amount of the voting securities is assessed accrued to the person. In excess of the $200 million, the object of the published from the official year beginning with September 3rd, 2004, same manner provided in 885 that reflect the percentage change of the gross national product of the year compared to gross national product for the year ending in September 30, 2003. Bill being except for the $50 million as adjusted and published and not except for the $200 million adjusted and published. 2. Any of the voting securities asset of the person that gave the manufacturer annual net sale of the total asset of the $10 million just for the published for many be acquired by the any of the person told for the annual net sales for $100 million just for the publisher more. And the voting securities except for the possible person with the engaged with the manufacturing total asset for the $10 million just for the published are being acquired with the aim of the person total asset for the annual net sale of the $100 million just for the publisher and any more. Any voting security asked for the person with an annual net sale of the totals of the $100 million or more are being acquired by any of the person told after the annual net sale of the $10 million adjusted and published or more. Any case of the tender of the office person voting security will be acquired with the person acquired with the file notification over subsection shall be the notification pursuant to the rules in subsection D. The waiting period required under subsection A of the shall begin with the date of the receipt of the Federal Trade Commission, the Assistant Attorney General in charge of the Antitrust Division, Department of Justice here, then referred to the Second Service and Assistant Attorney General thereof, the completed notification required under subsection A, or 2 with each of the notification complete with the notification consent with complete with the statement of the region with the compliance for the both person and the keep of the tender of the acquiring person. and B, end of the 13th day of the date such receipt of the K for the cash, tendering off of the 15th day, of the later day may be set under section E2 and the G2. Federal Trade Commission Assistant Attorney General may be the individual K for the terminating waiting period. Specified in paragraph 1, allowable to any person to proceed with any acquisition subject to this section promptly shall cover the publisher for the register of the notice, neither intend with the to take an action with such period with respect to the acquisition. As used in this section, the term voting security means any security with which a person, upon controversial entitle, the owner or holder thereof of the vote of the election of the director of the issue with respect to the unincorporated issue, the person exercising similar functions, amount of the percentage voting security after the person acquired withheld, any other person shall determine the aggregate amount of the percentage such for the voting security assessed the whole acquired by such for the person and each affiliate thereof. Following class for the transaction exempt from their section: acquisition, good realty transfer for the ordinary course of business, acquisition bond, mortgage, trust, obligation with no voting security, the acquisition voting security, and an issue with less than 50% centum voting securities which are owed and by the acquiring person prior to acquisition, transfer to federal agency with the state of the political subdivision thereof, the transaction specifically accepted with the antitrust law of the federal statute, transaction specifically exempted with the antitrust federal statute approved with the federal agency with the copies of the information documentary material field of the such agency contemporaneously filed with the Federal Trade Commission Assistant Attorney General. 7 on the transaction which require agency approval under Section 10E of the Homeowners Loan Act, of Section 18C of the Federal Deposit Insurance Act, or Section 3 of the Bank Holding Company Act of 1956, except for the portion of the transaction exempt under the paragraph such portion of the transaction A, subject Section 4C of the Bank Holding Company Act of 1956, and B, that does not require agency approval under Section 3 of the Bank Holding Company of 1956. Transaction 8, transactions which require agency approval under Section 4 of the Bank Holding Act of 1956, or Section 5 of the Homeowners Loan Act of 1933, if the copies of all of the information documentary material field of the sub of the agency contemporaneously filed with the Federal Trade Commission Assistant Attorney General at least 30 days prior to consumption of the proposed transaction, if the portion of the transaction is not except under the paragraph of the portion of the transaction shall be like 4K of the Bank Holding Company Act of 1956, but does not require agency's approval under Section 4 of the Bank Holding Company Act of 1956. Acquisition shall, for the purpose of the investment of the voting security, with the result of the trust acquisition security acquired with the held not to exceed 10% of the share of the outstanding voting security, with the issue with the acquisition voting security, the result of the share of the acquisition voting security acquired does not inquire whether directly indirectly acquiring persons per cent of their share of the outstanding voting security with the issuer. Acquisition solely with the purpose of investment with any of the banking association, trust company, investment with the company, and insurance company, with the voting security, with the pursuit of the plan, with the reorganization, dissolution, as such, in an ordinary course of its business, other acquisition, transfer transaction may be expected under Section D2B with the Trade Commission with the consortment with the Assistant with the Attorney General, the rule of accordance with Section Title 55, 553, Title 5 of the United States, consider the purpose of this section. One shall recover the notification required under subsection A with the shall the form of the containment of the documentary material of the information relevant to the proposed acquisition evidence necessary for the purpose to enable the Federal Trade Commission and Assistant Attorney General to determine whether the acquisition may be consummated, violate the antitrust laws, and may define the terms used within the section except for the requirements of this section, cover the person acquisition, transfer the transactions which are not likely to violate antitrust laws required, so the rules may be necessary for the appropriate to carry out the purpose of this section. The Federal Trade Commission for the Assistant Attorney General may, prior to the expiration of 30-day waiting period within give the cash tender of the 15-day waiting period within specified section B1 and section required the substantive for the additional information documentation material relevant to the proposed acquisition for the person required to file notification with respect to acquisition of subsection A of this section prior to the expiration of the waiting period specified in the subsection B1 of this section for any other officer or the director of the part agent of the employee with such a person. B1, the Assistant Attorney General of the Federal Trade Commission, such as each of the designated senior official who does not have the direct responsibility to review any enforcement recommendation over this section with a concern with the transaction with the issue with the hear any petition filed by such person to determine whether the request is additional information from the document material with unreasonable, ultimately unduly burdened or duplicated with the request of additional information and documentation material that is substantially compliable within the petition person. Review procedure of the petition filed pursuant to the clause of the judge shall include the reusable deadlines expedited review of the scope of the position reasonable to negotiate with the investigate staff in order to avoid undue delay with the merger review process. No later than 90 days after the date of the enactment of the Act of the Assistant Attorney General of the Federal Trade Commission shall conduct an internal review, implement implement the reform of the merger review process in order to eliminate unnecessary burden, most remove cost duplication, eliminate undue delay in order to achieve the more effective and the more efficient merger of the review process. No later than 120 days after the date of the enactment of the Act, the Assistant Attorney General of the Federal Trade Commission may issue an amendment with respect to the industry guidance, the regulations, and property manual, relevant policy documents to the extent of the appropriate to implement each for the reform of the subparagraph 5, no later than 100 days after the date of the enactment of the Act, the Assistant Attorney General of the Federal Trade Commission shall each of the report of the Commerce refer each of the agencies to the opposite of the subparagraph except for the end of the taken and implement in terms of the reform of the effect for the sub of the reform of the Federal Trade Commission. The Assistant Attorney General, in his or discretion may extend the 30-day waiting period within the case of cash tender offered with a 15-day waiting period specified with subsection B with the section additional period not more than 30 days in the case of the cash tender the offer of the 10 days after the date of the Federal Trade Commission. The Assistant Attorney General, as the case may be received of the person of the request made upon paragraph 1 in case of the tender officer for the acquiring person all information documentation material required to be submitted pursuant to such request, and B, such a request is not fully compliant information documentary material submitted with a statement of the reason for the non-compliance of additional period of the further extent that only with the United States District Court upon application of the Federal Trade Commission Assistant Attorney General pursuant to subparagraph section G2. Or if a proceeding instituted with an action filed with the Federal Trade Commission alleging with the proposed acquisition violation Section 7 under this Act and Section 5 of the Federal Trade Commission Act, or action filed with the United States alleging that the proposed acquisition violates the subsection such Section 7 or Section 1 or 2 of the Sherman Act of the Federal Trade Commission, the Assistant Attorney General will file with a motion preliminary injunction against consumption with as such injunction pendent light to serve the United States District with the Judicial District, which within respondent reside with the carries on with the business in which of the actions were in that he believed within the public interest required with the relief of the penitent, like pursuant in the subsection that there then upon with the filing such motion certification of the Chief Judge, such District Court shall immediately know the way the Chief Judge of the United States Court of Appeal for the circuit of which shall the court District Court located shall designate United States District Court Judge to whom such action shall be assigned for all the purposes. Any person offered the director partner thereof that will fail to comply with the provision section shall be liable to the United States for the civil penalty not more than $10,000 each day from the civil person violation and section, and such penalty may be recovered in civil action brought by the United States. 2. If any person, the officer of the director, partner, agent, of the employee thereof that fails substantially to comply with the notification requirement under subsection A with any of the request submission additional information documentary material under subsection E1 of the section with a written waiting period specified in subsection B1 of the may be extended under subsection E2 of the United States District Court. A may order complying with the B shall extend with the waiting period specified with the subsection B1 may have the extent of the under subsection E2 so there is substantial compliance except that in the case of the tender officer of the court may not exceed such waiting period based on the failure of the person whose stock is sought to be acquired to comply substantially with the such of the notification requirement that any of the such requests may grant the equitable relief as the court in discretion determined the necessary with the appropriate owner upon application of the Federal Trade Commission Assistant Attorney General. Any information documentary material field with the Assistant Attorney General of the Federal Trade Commission pursuant to this section which shall exempt from the disclosure under section 552 of Title 5 of the United States Code. No such information documentary material may be made public except by may be relevant to the administrative judicial action proceeding. Nothing in this section intended to prevent disclosure to either the body of the Congress or to any duly authorized committee, subcommittee of the Congress. 1.1. Any of the action taken by the Federal Trade Commission Assistant Attorney General failure the Federal Trade Commission Assistant Attorney General to take any action under this section shall not bar any proceeding, any other action with respect to the type of the acquisition any time under any other section of this section, any other provision of law. Alright, nothing contained in this section shall limit the authority of the Assistant Attorney General of the Federal Trade Commission to security any of the time, any of the documentary, but the material of the testimony, other information under the Antitrust Civil Procurement Process of the Act, Federal Trade Commission Act, any other provision. Beginning no later than January 1st, 1978, Federal Trade Commission concurrency with the Assistant Attorney General shall annually report with the Congress the operation of the section, shall report and shall include assessments of the effects of the section, and effect for the purpose of the need any of the rules promulgated the pursuant thereto, any recommendation for the provision of this section. Okay, if at the end of the period of the time provided with the section on the Saturday or Sunday in legal public holiday defined in section 6103A with the Title 5 United States Code, then such the period shall be extended at the end of the next day, but that is not a Saturday, Sunday, or legal public holiday. Or section 8A1, no person shall at the same time serve as a director or officer in two corporations other than in banks or banking association or in trust companies that are engaged in wholly in part in the commerce, by virtue of their business local operation competitive with eliminating competition by the agreement between the would constitute a violation of any of the antitrust laws. Each of the corporations that have capital surplus undivided profits aggregating more than $10 million are adjusted pursuant to paragraph 5 of the subsection 2, notwithstanding the provision of paragraph 1, simultaneously serve as a director or officer in any of the two corporations shall not be prohibited by this section if A, the competitive sale of either corporation or less than $1 million adjusted pursuant in paragraph 5 of the subsection, B, the competitive sales of either corporation are less than 2% of the corporation's total sales, the competitive sale of each of the corporation are less than 4% corporation total sales. For the purpose of this paragraph, the competitive sale of the means of the purpose of the paragraph, competitive sales mean with the gross revenues of the products sold within someone with a corporation competition with the other determined the base for the annual gross revenue of the sum of the products sold with the corporation last complete with the fiscal year. For the purpose of this paragraph, the total sale of the mean with the gross revenues all products and services sold with the one over the corporation of the corporation last completed in fiscal year, they eligible to direct for the officer of the under the provision. Paragraph 1 shall be determined by the capital and surplus. Undivided profit excluded the dividend was declared but not paid with the shackle each of the corporation and with the corporation last committed to the completed fiscal year. Alright, for the purpose of the section of the term meaning for the office or for the elected of the board directly for each of the fiscal year of the commencing with the September 30, 1990, for the $10 million, $1 million threshold subsection shall be increased with the degree of the October 1st each year of the amount with the equal the percentage increase with the degree of the gross national of the product with the determine the Department of Commerce and successor year of the end over the level so established for the year ending September 30th, 1989 as soon as the practicable not later than January 31st each of the year of the Federal Trade Commission shall publish the adjusted amounts required by this paragraph. When any person elected with the job of the director, the officer of the union of the corporation shall, for the provision here, they eligible for the time of the election, selection, the act for the tribe of the corporation, shall for the capacity of the eligibility, after the tribe of the capacity, shall not be defective in any of the provision here of the aim of the reason, any chamber of the capital with the surplus of the undivided profits, affairs of such of the corporation for whatever cover the until the expiration of the 1 year from the date of which the event with calling ineligibility occurred. Section 9, Section 10 is repealed by Public Law 101-588, Section 3, 104, Statute 2880, Section 11A with the authority to enforce compliance with Section 2, 3, 7, and 8 with the act of person respectively subject they are hereby vested with the term of the Transportation Board where applicable to common carry subject to the jurisdiction under Subtitle 4 with the Title 49 United States Code of Federal Commissions, Communication Commissions where applicable to common carry with engaged in wireless radio communication, radio transmission of the energy of the security of the transportation where applicable to the air carriers and foreign air carriers subject to the Federal Aviation Act of 1958 and the Federal Reserve Board where applicable to banks and bank association trust companies and Federal Trade Commission where applicable to all other character of the commerce to be exercised as follows. Whenever the Commission Board or Secretary vet the jurisdiction thereof shall have the reason to believe that any of the person violated any of the provisions Section 2, 3, 7, and 8, it shall issue for the servant upon with the side of the person with the attorney general of the complaint stating that in charge of the he with the respect with the contained with the notice for the hereupon of the day of the place for the air fixed the legs to 30 days with the after the service and of the complaint with the person shall complain with shall have the right to appear at the place for the time of the fixture for the show called for the why any order shall not enter for the Commission Board Secretary of the requiring such for the person see with the decision of the violation of the law so charged and said complaint with the Attorney General shall have the right to intervene appear with the shall of the proceeding that any of the person might make with the application under good cover shall be made allowed by the Commission Board or Secretary to intervene appear with the proceed and said proceedings by the counsel in person with the testimony any of the stuff of the proceedings shall be the brief and writing filed within the office of the Commission Board or Secretary upon such for the hearing of the Commission Board or Secretary of the case of the he shall be with the opinion any of the provisions said section that have been or being violated shall make of a report in writing in which of the each for the state of the finding within to his fact with it shall issue the cause of the be served upon such a person order requiring such a person to see the desist of the such violation divest itself out of its stock and divest itself out of the stock and or share capital asset with the help of the bid itself of the directors chosen contrary to the provision section 7 and 8 of this act, if any thereby with demand within this time fixed as or until the expiration of the time allowed with the filing petition for review of the notice of the petition when duly filed with the of the time of the petition for the review that has been filed with the time until the record of the proceeding have been filed with the Court of Appeals, United States of the Air, and thereafter provided with the Commission Board Secretary may any time within the time of the subject notice in such manner shall be deemed proper with the modified and set aside within whole within in part with any part with any order may be issued by under the section after the expiration of the time allowed and filed with the petition for review. No such petition has been duly filed with such for the time the Commission Board Secretary may at any time after notice opportunity by hearing a reopening with the alter or modify the set aside within whole or part with any of the report order made or issued by any under this section whenever to the opinion of the Commission of the Board Secretary conditions of acts of the law have so changed to require such action and if the public interest shall be required with the provided however that it is that said person may have within 60 days after service upon him or is said report in order to enter the reopening of option obtaining review thereof with an appropriate court of appeals of the United States of the man with the provided subsection C of the section. A person required to the order of the Commission Board Secretary to see if any of the violation obtained with the review of the order court appeal with the United States with any of the which of the violation occurred within any which the person reside with the care of the own business by filing into the court within 60 days after the date of the service of the order with the written petition praying with the order of the Commission of the Board Secretary to be set aside with a copy of such petition shall be forthwith with the transmitted clerk of the court of the Commission Board over the Secretary of the Airpine with the Commission Board and Secretary shall file in the court the recorded proceeding with this provided in section 212, 2112 of the Title 40 United States Code. Upon such filing with the petition, the court shall have the jurisdiction proceeding over the question determined if they are with the concurrent with the Commission Board with the Secretary until the filing record shall have the power to make with them enter with the decree with affirming and modifying and setting over the side of the order of the Commission Board Secretary and enforcing the same with the extent that such orders is affirmed to issue. Such rights ancillary and jurisdiction for the necessary for the in judgment for the prevented injury for the public competitive dependent for the light finding of the Commission of the Board Secretary as to the fact that the support of the substantial evidence shall be conclusive for the extent of the order of the Commission of the Board Secretary is and affirmed that the court shall issue its own order commanding commanding obedience from the terms of such of the order of the Commission Board Secretary, either of the party shall apply with the court to leave the use of the additional evidence and shall show with the satisfaction of the court that such additional evidence of material that there were reasonable grounds for the failure to deduce such evidence and proceeding before the Commission Board and Secretary of the Court may be the order of the additional evidence to make before the Commission of the Broad Secretary of the be adduced upon the herein such of the manner upon such a term and conditions as the Court may seem proper. The Commission Board Secretary may be modified in findings and in fact with to make new findings by reason of the additional evidence taken shall file such modified with the new findings within support of the substantial of evidence should be conclusive within recommendation if any of the modification setting of the side of the original order with the return such of the additional evidence to judgment the decree of the court shall be final except as the same shall be subject to the review of the Supreme Court upon statutory as provided in section 1254 of the Title 28 United States Code. Or upon filing with the record with the jurisdiction of the Court of Appeal with the affirm and the enforce the modified and set aside by the order of the Commission Board and Secretary shall be included with the order of the Commission of the Board with the Secretary of the judgment of the Court that enforce the same shall be the anyways relieve absolve any of the person from any liability under antitrust law of the complaints ordered with the other process of the Commission of the Board with the Secretary under the section may be served by anyone duly authorized by the Commission Board and Secretary either with one of the delivering the copy thereof with the person to be served with the entity with the member of the partnership to be served with the President Secretary of the other executive officer, the director of the corporation to be have served by leaving the copy thereof of the residence or of the principal office of the belief of the business of such person by mailing registered certified mail with a copy of the address touch of the person his or her residence of the principal office of the place of business verified return by the person serving the said with a complaint and order of the other process setting forth the manner and said services shall be proof of the same and the return post office with the receipt with the said of the complaint order of the other process of the mail by registered certified mail with the order for said shall prove of the service of the same. Any order issued on subsection B shall be made come final with upon the expiration of the time allowed with the filing petition review the insert of the petition that had been filed duly filed with the time the Commission Board Secretary may therefore after a modified set aside in order to extent provided in the last sentence subsection B upon expiration of the time allowed with the filing a petition for the said statutory in order the Commission Board in section Secretary had been affirmed with the petition with a review that has been dismissed with the court with appeal with no petition with the Centauri that has been duly filed with the undo with the denial with the petition with the Centauri with the if the order with the communication board. Secretary had been affirmed with the petition with a review that has been dismissed with the Court of Appeals upon expiration of 30 days for the day of the issue of the mandate of the Supreme Court with their own court dates and over the order of the Commission Board. Secretary of the affirmed with the petition for the review to be dismissed. Supreme Court directs for the order of the commissioning board secretary to be modified and set aside by the order of the commission board of the secretary rendered in accordance with the mandate of the Supreme Court shall become final upon the expiration for 30 days from the time it is rendered unless within such 30 days either party has instituted proceeding to have the subject order corrected with the court of the mandate in which event of the order commission board and secretary shall become final when so corrected. If the order of the Commission Board and Secretary is modified with the Court of Appeal with one at a time allowed with the filing of the petition, Centauri if it has expired with no such petition has been duly filed with the petition with the Centauri has been denied with the decision of the Court has been affirmed with the Supreme Court within or with the Commission of the Board Secretary with the render of the Court with the mandate with the Court of Appeals shall become final with the expiration of 30 days from the time such order of the Commission Board Secretary was rendered unless the third day 30 days either party was instituted proceeding to have set such order corrected so that it will be accorded with the mandate with the event with the order commission and board and secretary shall be final when so was corrected. If the Supreme Court orders rehearing in the case of the remand by the Court of Appeals Commission Board or Secretary of the rehearing, if the time allowed with the filing of the petition with the Centauri that has expired with no such petition has duly filed with the petition with the Centauri that has been denied. 3. Decision of the Court has been affirmed with the Supreme Court with the order of the Commission Board Secretary rendered upon with the rehearing shall become final in the same manner as though with no prior with the Commission Board and Secretary has been rendered. As chief of the section of the term mandate, within this case of the mandate that has recalled prior with the expiration of 30 days from the day of the issuance thereof the may be defined with the mandate. Any of the person who violates any of the order issued of the Commission and the Board Secretary in their subsection B after such order to become final while such order in effect with such forfeiture and pay with the United States with the civil penalty not more than $5,000 for each violation will accrue with the United States and may be recovered with civil action brought with the United States each of the separate violation and each of the order shall separate offense and except in the case of the violation through the continuity failure of the neglect to obey the final order commission board secretary each for the day with the continuity of the failure of the neglect shall be deemed separate offense. Section 12, that any suit with an action from the proceeding under the antitrust law against the corporation may be brought with not only judicial the district whereof the inhabitant must as or with any of the district whereof that may be defined with the transaction of the business, all of the process of the case may serve within the district which is an inhibitant with whether it may be found. Section 13, that in any of the suit with the auction proceeding with brought with the behalf of the United States subpoena with the witnesses who have the required with the attendant with the court with the United States with any judicial district, in case civil criminal arising under the antitrust law with the maid run with any of the appropriate district provided that in the civil case with no writ of subpoena shall issue for the witness living out with the district in which the court is held with a greater distance than 100 miles from the place of the holding of the same without permission of the trial court being first held upon the proper application cause shown. Or Section 14, whenever the corporation shall violate any of the panel provision of the antitrust law, the violation shall be deemed to be also for the individual directors, all of the agent of the corporation shall be authorized to order done any of the acts of the constitute the whole of any of the part of the violation. Such violation shall be deemed misdemeanor upon with the conviction thereof that any such director, officer, of the agent shall be punished by a fine not exceeding $5,000 or by imprisonment for the not exceeding 1 year, both in the discretion of the court. Section 15. The civil district courts of the United States, they hereby invest with the jurisdiction to prevent the restriction on violation of the shall be duty of the surveyor, several district of the attorney with the United States, with the respect of the district, with the under the direction of the attorney general, the of the proceeding and equate and equity to prevent and restrain such violations. Such proceedings may be the way with the position set forth in case of the praying with itself of the violation shall be enjoyed, but the otherwise prohibited. When the parties complain shall be have the fully been duly notified with such position when the court shall be proceed as soon as may be for the hearing with the determination of the case of the pending for the position with the before the final decree of the court may at any time make of the temporary restraining order of the prohibition shall be deemed the justice as the premise of the whenever shall appear with the court before the any of such proceeding may be depending that the end of the justice scribe that another party shall be brought before the court may cause them to be summoned, whether it be reside with the district in which the court is beheld, whether or not subpoenas the end of the may be served in any of the district of the marshal thereof. Section 16, that any of the person of the firm of the corporation association should be entitled to issue with injunctive relief that any of the court of the United States would have the jurisdiction over the parties again for the threatened law for the damage of violation of antitrust law, including Section 2, 3, 7, and 8 of this Act, when under the same condition, principles of injunctive relief against the threatened conduct will cover the loss of the damage of the granting against the threatened conducted will cause the loss of the damage of the granting by courts of equity under the rules governing such a proceeding upon the equation of the proper bond against damages for injunction improvidently granted, showing the danger of the irreparable loss and damage immediately. Preliminary injunction may issue, provided that nothing herein with the contained shall be construed that entitle any person, firm, corporation, association, except the United States, to bring suit with the injunctive relief against any with the common carrier subject to the jurisdiction of the United States. Surface Transportation Board under Subtitle 4, Title 49, United States Code. Any action under section in which the plaintiff subsection substantially prevails, the court shall be awarded the cost of suit, including a reasonable attorney fees for such plaintiff. Section 17, 18, and 19. Section 20, the no restraint order of the injunction shall be granted with any of the court, United States, with the judge thereof, with any of the case employed with the employees of the between employed with the employed between the employed with between person employed person seeking employment involved with the growing out with the dispute with the concerning term of the condition of the employment unnecessary to prevent the irreparable injury of the property right, property making with the application for the which of the injury was not adequately remedied due to the law. Such priority of the property right must be described, particularly an application which must be in writing and sworn to the applicant by his agent and attorney. No such restraint orders injunction shall prohibit any of the person with the singly within conflict for the terminating any of the relation with the employees of the team with to perform any of the work of the labor for the recommending the advice and persuading others or peaceful means to do so with the attending with any of the place where any of the stuff of the person may be lawfully be with the purpose of the peaceful with obtaining with the communication information from peacefully persuading any person with the work of the stand from working or from ceasing to patronize or to employ any of the parts to such a dispute with the recommending advising persuading others to be by peaceful lawful means to do so for the paying and the giving to and the withholding from and any of the person engaged in a dispute with any strike of the benefits other money for the things to value with the peaceable assembling in the lawful manner lawful person of the undoing and any of the act that might lawfully be done in absence and such dispute by any part thereof that shall any of the acts specified in this paragraph considered a held violation of any of the law of the United States, section 21, 22, 23, 24, 25, and 26. Except as provided in subsection B, it shall be unlawful to any person engaged in the commerce within court such for the commerce directly, indirectly, to impose any condition, restriction, agreement, understanding that limits you with the credit instrument that any of the transaction concerning sale or resale of the transfer of the gas or whole other synthetic motor fuel with equivalent unusability in case of the which there is no similar limitation transaction concerning such person conventional motor fuel. Okay, So provides subsection B, unlawful to any person engaged in commerce in course of the commercial directly, indirectly to impose any condition, restriction, agreement, understanding that limits you to the credit instrument and any transaction, sale, resale, transfer of the gas, all other synthetic motor fuel equivalent usability in any case in which there is no similar limitation transaction concerning person conventional motor fuel. Or two, the other reasonable discriminate against unreasonable limits for the sale and resale, transfer, gas haul, other synthetic motor fuel equivalent usability in any case in which synthetic conventional motor fuel is sold for use, consumption, and resale within the United States. Fuck. Alright, nothing in this section, any of the other provision of the effect of the date of the enactment of this act, which is specifically applicable to the sale of the petroleum. Nothing in this section, any of the provision of the law in effect of the date of the enactment of this, which specifically applicable to the sale of the petroleum product, should preclude any person referred to in subsection A with imposing a reasonable fee for credit on the sale, resale, transfer of gas or other synthetic motor fuel referred in subsection A, and such fees equal no more than the actual cost such person of extending that credit. Alright, prohibitions in the section shall not apply to any of the person who will availably sufficient supply of the gas haul or the other synthetic motor fuel with equivalent usability to satisfy customer needs to satisfy with the gas haul with the other synthetic fuels are made available in terms of the condition which are equivalent to terms and conditions on which such persons of conventional motor fuels products are made available. Nothing in this section preclude any person referred in subsection A with requiring reasonable labeling with a pump that dispenses in gas oil with the other synthetic motor fuel referred to in subsection A to indicate that it is appropriate to use civil gas oil or other synthetic motor fuel that is not manufactured, distributed, and sold by such person. Preclude such person with the issuing an appropriate disclaimer of the product liability with the damage of the resulting from the use of the gas oil with the other synthetic motor fuel. Require such person with the provided advertising support with the gas oil with the other synthetic motor fuel, or require such person to furnish and provide and such for the person's own expense with any additional pump, tanks, and other related facilities required the sale of the gas oil with the other synthetic motor fuel as used in the section of the United States to include several states of the District of Columbia, any territory of the United States, any ancillary or possession in other places over the jurisdiction of the United States. Section 27. Alright, section 27 is subject to the subsection B through D with the conduct of the practice of the agreements of the person with the business of the organization, professional Major League Baseball directly relating to affecting employment of Major League Baseball players to play baseball with a Major League level, the subject of the antitrust law of the same, the stimulus of the conduct of the acts, practice of the agreements would be subject to the antitrust law if engaged by a person in any of the other professional sport business affecting the interstate commerce. No court should rely on enactment of this section for the base for the change of the application of the antitrust law of any of the conduct of the acts or the practice of the agreements other than those that set forth in subsection A. This section does not create and permit implied cause to any of the action, any challenges on the antitrust laws or otherwise apply with the antitrust laws to any conduct, any practices, or agreements to do not relate to the effective employment of the Major League Baseball players to play baseball with the Major League level, including but not limited to any conduct, acts, practice, for the agreements of the person engaged in the conduct of the participating in business, organized professional baseball relating to affecting employment of the baseball with the minor league level, any organized professional baseball, amateur or first-year player, drafter, any of the reserve clause of the apply with the minor league players. And it was a miracle, the agreement between the organized professional Major League Baseball team of the National Association of Professional Baseball Leagues, commonly known as Professional Baseball Agreement, the relation between the organized professional Major League Baseball, organized professional minor league baseball, any other material relating organized professional baseball, minor leagues, any conduct, any practice of the agreements of the person engaged in conducting, participating in the business, organized professional baseball relating to affecting franchise, expansion, location, relocation, franchise ownership issue, including owner transfer, relationship between officer of the commissioner of the franchise, or owner of the marketing, sales, entertainment product, organized professional baseball, licensing, intellectual property owned with the help of the organized professional baseball team, individually collective or collectively. Any conduct, act, practice, agreement that is protected by Public Law 87331, commonly known as the Sport Broadcasting Act 1961, relationship between the person and the business of the organized professional baseball, umpires with the other individuals who are employed in business or organized professional baseball, so this person, any of the conduct of the acts, the practice, the agreements of the person not in the business of the organized professional Major League Baseball. Only a Major League Baseball player has to stand in suit for the under section. The furthest for the section Major League Baseball player is person who is a party of Major League Baseball, contract playing baseball at Major League, a person who is a party with a Major League player with a contract playing baseball at a Major League level at the time of the injury that is subject to the complaint. Person who has a third-party Major League player contract that have been played baseball with a Major League level that who claims to have been injured in his efforts to secure a subsequent Major League Baseball contract, alleged violation of antitrust laws provided here, however, that for all purposes of the paragraph, the alleged antitrust violation shall include the conduct of the acts of the agreements of the person, business, organized professional baseball relating to effective employment to play baseball, minor league level, including organized professional baseball, amateur for the first year, player draft, any reserve clauses apply to minor league players. Person who is a party of the Major League player's contract with playing baseball at the Major League level, the conclusion last fully, or of at the Major League level at the conclusion of the last full championship season, immediately preceding the expiration of the last collective bargaining agreement between the person and the business of the organizational professional Major League Baseball, and exclusively collective bargaining representative of the Major League Baseball players. Alright, using the section person means any of the entity included with an individual, partnership, corporation, trust, unincorporated association, combination, association, there used in this section. The National Association of Professional Baseball Leagues, member leagues, clubs of these other leagues, are not in the business of the organized professional Major League Baseball. In this case, involving the conduct, acts, of the practice of agreements that directly relate and are effective with both employment of Major League Baseball players to play baseball at the Major League level. It also relates to the effect of any other aspect of the organized professional baseball, including but not limited to employment of play baseball at the minor league level. The other areas set forth in subsection only those component of the portion and aspect of the conduct, act, practice for the agreements that directly relate to the effect of the employment of a Major League player to play baseball with the Major League that may be challenged under subsection A. The only extent that they directly relate to the effect of the employment of Major League Baseball players to play with a Major League level. Alright, last page. As used in subsection A, interpretation of the directly should not be governed by any interpretation. 151, intent sequence 29 U.S. Standard Code has amended nothing in section construed in effect of the application of organized professional baseball non-statutory labor extension for the antitrust. Scope of the conduct, act, practice of the agreements and covered in subsection B shall not apply with the narrowly construed. Alright, section 28. If any clause, section, paragraph of the part of this act is for any reason adjudged by any court competent jurisdiction to be invalid, such judgment shall be not in effect, impair, invalidate remainder thereof, but shall not be confined into operation clause, sentence, paragraph, part thereof directly involved in controversy, and such judgment shall have been rendered. This was the Clayton Act. As amended through Public Law 108-237, ended enactment in 22nd in 2004.